Welcome to this third podcast on the issues of child abuse and child protection. Just a brief warning, some of the cases in this particular area can be quite confronting and deal with quite explicit facts about potential abuse of children. In this podcast though, our focus will be on the concept of abuse and how it operates within Part 7 of the Family Law Act 1975. In this podcast, we will review the concept of abuse as defined in the legislation. We will examine the interrelationship between multiple sections of the Family Law Act and how the concept of abuse permeates throughout Part 7, and we'll be looking at some of the specific cases concerning unacceptable risk of child abuse. Section 4 of the Family Law Act defines abuse. There has long been a definition of abuse in the Act, but the definition was modified and extended in the amendments that came into effect in 2012. Section 4 makes it clear that abuse is A, an assault including a sexual assault of a child, or B, a person involving the child in a sexual activity with the first person or another person in which the child is used, directly or indirectly, as a sexual object by the first person or the other person, and where there is unequal power in the relationship between the child and the first person. Or causing the child to suffer serious psychological harm, including, but not limited to, when that harm is caused by the child being subjected to or exposed to family violence, or serious neglect of the child. Note the link there between family violence and the definition of abuse. Now it is those latter two paragraphs, paragraph C and paragraph D, that were added to the definition of abuse in 2012. The term abuse appears in many different sections for many different purposes throughout Part 7. At pages 340 to 341 of your prescribed textbook, Family Law Principles, there is a list of a number of different sections where the concept of abuse is relevant. Some of them are set out in the slide in front of you. We will not be able in this podcast or in this module to deal with all of the sections, but we will examine some of them in some detail. Section 60cc2b, that you'll now be quite familiar with, lists one of the primary considerations as the need to protect the child from physical or psychological harm, from being subjected to or exposed to abuse, neglect or family violence. Note that there are two concepts on the literal reading of this section. The first is being subjected to abuse. The second is being exposed to abuse. You might recall that in previous podcasts about family violence, I mentioned that there is a specific definition of being exposed to family violence. Unfortunately, there is no equivalent statutory definition of being exposed to abuse. You will by now also be familiar with Section 60cc(2)A, which provides the consideration of protecting a child from physical or psychological harm from being subjected to or exposed to abuse, neglect or family violence should be given greater weight than the benefit to the child of having a meaningful relationship with both of the child's parents. On this next slide, I have emphasised some provisions, or some words rather, in section 61(D)(A). You'll remember that the presumption of equal shared parental responsibility arises in certain cases. Section 61(D)(A) subsection 2 provides that the presumption does not arise if a parent has engaged in, and that's my emphasis, abuse. So, on the literal reading at least of section 61(D)(A)(2), any act of abuse, even if it occurred in the past, ought to be enough such that the presumption should not arise. Now, having considered some of the case law, it may not be as clear as that, but that's what the wording of the section actually says. There is a bit of framework that we need to remember. If abuse is raised as an issue in a case, or risk of abuse, or unacceptable risk of abuse, a court is still required to consider all of the relevant matters in Part 7. When looking at the case law, you will see that the determinations of fact of abuse are of significant weight, as they should be, but not of themselves determinative of the outcome. There are a couple of procedural matters that I'd like to consider before going on to the case law. Section 67 Z provides a mechanism for a state welfare authority, such as the Department of Communities, Child Safety and Disability Services, to be made aware of evidence of abuse raised in family law proceedings. If a notice of risk of abuse is filed, then a court is obliged to send the notice, that is, where the notice raises issues of abuse, to the relevant state welfare authority, who then can decide whether or not to take action in the matter. Without this, there is no mechanism for the family law courts and state welfare authorities to exchange information with each other. Sections 91B and 92A deal with the ability of persons and state welfare agencies to intervene in family law parenting proceedings. Section 91B provides that a court can request, in any proceedings relating to a child, whether or not the risk of abuse is raised, that a proper officer of a state welfare agency intervene in the proceedings. Whether or not the court requests it, a number of individuals have a right to intervene in proceedings where issues of abuse are raised. In such circumstances, Section 92A says that all of the persons listed, including a proper officer of a child welfare agency, are entitled to intervene in the proceedings. Note that the section includes the person who is said to have abused a child or is at risk of abusing a child, even if that person is not a parent or family member. We will now turn to the case law. Just a reminder though, there is some difficulty in looking at the individual cases because of the legislative context in which they were decided. Pages 336 to 339 of the prescribed textbook sets out a bit of the history of the definition of abuse and some of the amendments, and that might assist you in interpreting the case law. As a last preliminary matter, there are two issues that you should be aware of. The first is that courts, on a practical level, have significant difficulties with the nature and type of evidence before them about potential abuse or unacceptable risk of abuse. The second issue, and we will deal with some of this in a moment, is that the High Court and Full Court cases have been the subject of some academic criticism. Starting with the practical, the issues facing trial judges are commented on by the Honourable Mr Justice Murphy in the decision of Donaghy and Donaghy. This case is not prescribed reading, but a summary of His Honour's comments are extracted at page 876 of your prescribed casebook. Some of the issues faced by a court include the age, including a tender age, of the child, the absence of physical evidence, and a genuine belief by a parent that the other parent has been responsible for abuse of the child. It is important to think about the context of cases that come before family law courts for consideration. If, for example, there was sufficient evidence of abuse of a child for police to charge a person with a crime, or a parent with a crime, upon which it would follow that there is, on the face of it, sufficient evidence to prove the matter beyond a reasonable doubt, then a civil court is unlikely to have to determine the issue on the balance of probabilities. The cases that often end up before the family law courts are those where the evidence falls short of, or where the police are unable to, charge someone with a crime. The court is then left with the task of having to weigh up highly contested evidence on the balance of probabilities. I will deal with some of the cases explaining the unacceptable risk test in a moment. But before I do that, I'm going to direct you to some of the criticism of that test. Patrick Parkinson, in his article extracted in his casebook, which is your prescribed casebook, at page 882, describes the unacceptable risk test as indeterminate and circular, and contrary to the fundamental principles of findings of fact. He queries whether, in the absence of a finding of fact about whether or not abuse occurred, any court can properly assess future risk and whether that risk is unacceptable. But let's now turn to what is known as the unacceptable risk test, and also look at the circumstances in which the court may or may not make a finding that abuse occurred. We now turn to the High Court of Australia decision of M&M from 1988. That case is extracted at some length at pages 877 onwards in your casebook. The mother had made allegations, and I stress that I use the term allegations as it is reported in the decision, that the father had sexually abused the child. The trial judge was not satisfied on the balance of probabilities that the father had abused the child, nor was the trial judge satisfied that the father had not abused the child. The option of supervised time was considered by the trial judge and rejected. The trial judge found that there was a possibility of sexual abuse, and the best way to eliminate that possibility was to make an order that the child live with the mother and have no time with the father, or the equivalent wording in 1988. On appeal, the High Court said that in considering an allegation of sexual abuse, the court should not make a positive finding that the allegation is true unless the court is so satisfied according to the civil standard of proof with due regard to the matters set out in the case of Briginshaw and Briginshaw. Now, Briginshaw and Briginshaw is itself a decision from the High Court of Australia from 1938. However, the passage quoted from that case in M&M appears on your slide. The full paragraph from the 1938 decision, that I'll paraphrase for you, says that, except upon criminal issues to be proved by the prosecution, it is enough that the affirmative of an allegation is made out to the reasonable satisfaction of the tribunal, that is, to the person determining facts in proceedings. In considering whether the allegation is made out to a reasonable satisfaction, the factors to be considered are the inherent likelihood or unlikelihood of the occurrence, or the gravity of the consequences that flow. In such matters, reasonable satisfaction should not be produced by inexact proofs, indefinite testimony, or indirect references. Turning back to M&M, the High Court then went on to consider, in that case, a number of formulations of risk, such as element of risk, or real possibility. It was said in devising these tests, earlier courts had endeavoured to achieve a balance between the risk arising from a determination that the child was sexually abused and the possibility of benefit to the child from what was then described as parental access. The High Court's view was that the test, as best expressed, was that a court would not grant custody or access to a parent if it would expose the child to an unacceptable risk of abuse. Now, while the source is a little old, there's a very effective summary of the decision of M&M from the Honourable Alastair Nicholson in his 1989 article, Child Sexual Abuse, Problems in Family Law. The important points from the article are on the slide. They are that a court should avoid making a positive finding on balance that child abuse occurred. If such a finding is to be made, it will need to be to the reasonable satisfaction standard from Brickenshaw, and thereafter an overall assessment should be undertaken of the level of risk. If the risk is unacceptable, then orders for time or contact or access, as it would have been described in 1989, should not be made. In 1995, that is, subsequent to the case of M&M, the Commonwealth Evidence Act was enacted. Section 140 of the Evidence Act in effect codifies the Brickenshaw test. While always, in civil proceedings, findings of fact should be made on the balance of probabilities, it is appropriate for a court to take into account the nature of the subject matter of the proceeding and the gravity of the matters alleged. The full court considered the issue of the appropriate standard of proof directly in the 2004 case of Re W sex abuse standard of proof. Just note the citation there. It is an FLC citation. All FLC cases can be found by logging in to the CCH Intel iConnect database through the databases link on the library page. In this case, then Chief Justice Nicholson, at first instance, ordered that the appellant be prohibited from having any contact with the children. The evidence in support of the finding that abuse had taken place is summarised at pages 79211 to 79212 of the reported decision, and in summary, and again I'm paraphrasing, was: the evidence firstly consists of that of the wife and the maternal grandmother and grandfather as to the responses and behaviour that they observed in relation to the children and the disclosures made to them. Secondly, it involves the disclosures made to Ms C and Senior Constable B as to their interviews with the children. Next, there is the evidence from Dr L, who is a general practitioner, of an interview with the child and her medical history, and from Dr H, a paediatrician, as to her observations on examination of the child. Finally, there is the evidence of Dr A, the court-appointed expert, together with that of the psychologist, Mr P. There is also evidence of the child's school teacher as to behavioural change in the latter part of 2002. On the husband's side, there is his evidence denying that any abuse occurred, and the evidence of a teacher as to the withdrawal by G of her allegations. That's the child of her allegations. The trial judge also rejected the father's proposal that the father's brother's partner, a teacher, be a supervisor. At pages 79217 to 79218, the full court said this, and I'm paraphrasing: there is a very high standard by which a court needs to be satisfied on the balance of probabilities that something has actually occurred, unless such a rigorous approach is taken, where the often inevitable result of a positive finding is a cessation of the relationship between a parent and a child. There is a major risk of inflicting upon the parent and child the disastrous effects of a positive finding that is reached in error. The termination of a worthwhile relationship between the parent and child ought in most cases be the course of last resort. The court should not shy away from reaching such a result in an appropriate case, but at all times judges should be conscious that the adversarial or inquisitorial systems often reach results that are artificial. The truth does not always come out. The court went on. A false negative finding accompanied by appropriate safeguards as to the future relationship between parent and child, such as adequate supervision to guard against possible abuse, may be far less disastrous for a child than an erroneous positive finding that leads to a cessation of the parent-child relationship. The court needs to remain conscious of this imperfection at all times. Ultimately, the full court found in this case that the trial judge's rejection of the appellant's denials, based on findings of credit against the appellant, were unsound. Accordingly, the positive finding of abuse was unsound and the appeal was allowed. Napier and Hepburn from 2006 considered an order made by a trial judge that a father have supervised contact. The basis of the finding of unacceptable risk of abuse by the trial judge appears to have come from a number of factual circumstances which are set out at page 81110 of the full court's reasons. They are, and I will summarise and I say sanitise also a little bit, that the father had an underlying disposition to inappropriate sexualised behaviour as alleged by the mother, including the father having made extreme sexual requests of the mother during their relationship, an unhealthy interest in a 12-year-old girl when the parties were living together, the father being in possession of a type of soft pornographic book containing images of semi-naked pubescent girls, and the father attending a brothel about the time of the parties' separation. The mother had alleged that the father had had a sexual relationship with a different underage girl, but the trial judge accepted the father's evidence that he had a relationship with an 18-year-old woman that lasted for about 4 years. The full court said this: there remained an obligation on the trial judge to not only evaluate the harm that might befall the child if there is a future act of abuse, but also evaluate the prospect of such an act occurring. This is not a search for a solution that will eliminate any prospect of serious harm. It is a search to balance the harm that will follow if the risk is not minimised, and the harm that will follow if a normal, healthy relationship between a parent and child is not allowed to prosper. The failure of the trial judge to clearly set out the means by which the harm was evaluated, and therefore to adequately explain the conclusion the trial judge reached, was not clear, or sufficiently clear, and accordingly the appeal was allowed. The 2007 decision of Johnson and Page is extracted in your prescribed casebook at pages 885 onwards. There are 7 matters which the full court considered should be relevant not only to the questions of findings of fact, but also to the issue of unacceptable risk. Those 7 matters are set out on your slide. The approach from Johnson and Page then is not to expressly divide up the issue of findings of past acts of abuse and present evaluation of unacceptable risk. These questions seem to be considered all together. The full court also noted that the appropriate reference for the high level of standard of proof on the balance of probabilities is a reference to the Evidence Act as it stands today, not Briginshaw. On your slide I have suggested, and it is my suggestion only, it is not in any way authoritative, a way in which you could work through an advice if an issue of abuse is raised. The steps are: 1. Can a finding of fact be made about whether or not abuse occurred on the civil standard of proof, bearing in mind the wide definition of abuse that includes psychological harm and neglect? That proof would need to be in accordance with the requirements of Section 140 of the Evidence Act. You may also wish to specifically refer to the Briginshaw elements, and you could cite Briginshaw if you wished, or at least be clear that inexact evidence would not be sufficient for a court to make a positive finding of fact. 2. You may wish to advise that it may not be possible for a court to make a finding of fact of whether or not abuse occurred, and it may be that a court decides the matter without making a finding of fact about whether or not abuse have occurred. 3. Irrespective of whether or not a finding is made about the fact of abuse, the question then is, are the current circumstances, assessing the whole of the evidence, including that which might be described as the unproven abuse, sufficient to demonstrate a current unacceptable risk of abuse? In doing so, you might wish to cite authorities such as Johnson and Page to emphasise that the focus is not so much on a positive finding about past acts, but whether the accumulation of all of the evidence leads to a finding of unacceptable risk now or in the future. 4. Even if, on the balance of probabilities, there may be sufficient evidence otherwise to find that there is unacceptable risk of abuse, are there any other orders or safeguards, such as injunctions or orders about specific issues, that could sufficiently ameliorate those risks, to ensure the safety of the child in accordance with Section 60cc? That finishes our discussion of the difficult issue of unacceptable risk of abuse and its operation in Part 7 of the Family Law Act. This also means that module is now concluded. Thanks for listening. See you next time.